Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
Defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Cops these days seem to have a knack for overestimating their authority and committing horrible crimes under the guise of protecting civilians. These are the cops no one likes, so there's nothing more satisfying than watching a judge give them the exact karma they deserve. Today, we check out exactly this. In June 2023, the Indiana State Police launched an investigation into Clark County Sheriff Jamie Knoll. They discovered he had been misusing state funds, stealing over $5 million in taxpayer money to purchase luxury cars, cigars, suits, and even a personal Cessna airplane. He was immediately removed from his position and charged with 25 felonies. Here's when this corrupt cop made his first court appearance.
Date of birth?
12/18/70.
And that will make you how old?
52, sir.
Special Prosecutor Hurdle has charged you with 15 counts of criminal conduct. And I'll go through it. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1 that on or about a period of time from November the 9th, 2018 and August the 16th, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain either directly or indirectly an interest in or control of property or an enterprise contrary to the form of the statute in such case made and provided. Count 2, theft as a level 5 felony. Personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4.
Jamie's wife, Misty, and their daughter, Casey, also face multiple felonies. It's truly bizarre how this sheriff engaged in such blatant and extensive corruption while remaining in the department for so long.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff, assigned walkery duties on your personal property, rental properties, father-in-law's property, pole barn, and property of the Utica Fire Department. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment as sheriff of Clark County relating to Brent Fisher. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail if treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
The next question is, usually you intend to hire a lawyer, but you obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county.
Jamie showed no remorse as he sat through the proceedings, during which the judge read out the 15 charges against him. Afterward, the state attorney argued that he should be held without bail. However, the judge eventually decided otherwise, not knowing it would later prove to be a big mistake.
The passport to you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, sir.
He will surrender all firearms except one shotgun of his choice to Indiana State Police, be it from the country or, as Mr. Wilder said, Washington County. I keep my shotgun with double-aught near me, along with my .45, but I think one shotgun for personal protection is appropriate for him to maintain. He will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you're so pleased.
From this point on, the judge made one thing very clear.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand?
Yes, Your Honor.
Okay.
And then, Judge, the issue of return of all other items seized, we can just take up in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, sir.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor.
Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
Jamie was granted bail, but it didn't last long as he ended up breaking the sole pact he made with the judge. In March, officers raided his home and discovered multiple hidden firearms. He was then summoned to another court hearing, and this time, the judge didn't mince words.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
Surprisingly, Jamie once featured in the A&E series 60 Days In, and the judge made sure to reference that while punishing him for this offense.
What is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Ertl's original argument that he's trying to make that I sustain, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It was your burden. It's your responsibility. And today, the court will enforce that. Take him on.
Jamie Knoll was sentenced to 60 days in prison and currently faces 31 felonies. He's about to go to trial soon and is looking to be in jail for a much longer time. Now, watching this judge tear into the now ex-sheriff may have been satisfying, but the next judge on the list takes things to a whole new level.
Classified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
Officer J. DeValconaire was found guilty in the death of 26-year-old Cameron Lamb. Judge Dale Youngs announced his sentence but had some important words for him before doing so.
Parties have a right to expect that no matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here. And as a result, I've concluded as follows. There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead. And Eric DeValconaire killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel.
It's evident that this officer was feeling no remorse at all for what he had done, as his demeanor stated so.
For those events tragically concluded with the actions of Troy Schwam and the defendant. Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey Troy, wait." At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage.
Cameron Lamb was violently murdered by the racially motivated officer. The 26-year-old was calmly sitting in his pickup truck when this freak of an officer shot him dead.
Then Sergeant Schwam and Eric DeValconaire arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things.
After siding with Cameron the whole time and acknowledging that the officer slaughtered him, the judge eventually started to develop a soft corner for the officer.
Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him.
Ultimately, Judge Dale announced the sentence, which felt like a slap on the wrist for this corrupt cop.
December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family. Cameron Lamb is dead. Eric DeValconaire killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
None from the state.
No, sir.
Eric DeValconaire, on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
6 years in prison for killing an innocent man while on duty feels like a light sentence. The judge extended some officers' protocol to Eric, making a joke out of the justice system yet again. With Eric standing motionless, having just heard his sentence, it was only a few moments later that his new reality began to kick in. While this officer was able to show some emotions, here's a cop who had no remorse throughout his entire sentence.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
Euclid police officer Michael Amiot was charged with repeatedly punching a man at a traffic stop. Although Michael claimed he only did it for self-defense, the judge had a different understanding.
In the Euclid Municipal Court, Cuyahoga County, Ohio, State of Ohio, plaintiff versus Michael Amiot, defendant, case number 19-CRB-00890, verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiot, not guilty of assault, a misdemeanor of the 1st degree in violation of Section 2903.13a of the Ohio Revised Code, as charged in Count 1. We do so render our verdict this 29th day of July, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiot, guilty of assault, a misdemeanor of the 1st degree, in violation of Section 2903.13A of the Ohio Revised Code as charged in Count 2. We do so render our verdict this 29th day of July. Verdict: we, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45A of the Ohio Revised Code, as charged in Count 3. We do so render our verdict this 29th day of July, 2022. Signed by all 8 jurors.
After 5 days of trial, Michael was found guilty of 1 count of assault and 1 count of interfering with civil rights.
On behalf of the defendant, do you wish the jury poll?
Yes, Your Honor.
Juror number 1, is this your verdict?
Yes, it is, Your Honor.
Are these your verdicts, I should say?
Yes.
Juror number 2, are these your verdicts?
Yes.
Juror number 3, are these your verdicts?
Yes, Your Honor.
Juror number 4, are these your verdicts?
Yes, Your Honor.
Juror number 5, are these your verdicts?
Yes.
Juror number 6, are these your verdicts?
Yes.
Juror number 7, are these your verdicts?
Yes.
Juror number 8, are these your verdicts?
Yes.
Anything further of the jury? Ladies and gentlemen of the jury, I want to thank you all for performing your civic duty. Your job was not to prove anything or disprove anything. Your job was to determine what was presented to you, determine the facts, apply the law, render a verdict. You did that. You should leave feeling that you've done your job. No second guessing, you've done your job. If someone else didn't, that's not your job. You've done it. With that, you will be discharged. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you. But again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
After thanking the jury, the judge ended the court proceedings. The next day, Michael, who had sat through the trial with a straight face and no visible emotions, was sentenced.
Based upon the evidence presented and the pre-sentence investigation, the court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Amiot?
Just what counted?
Given the length of time involved here, the court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
Thank you, Your Honor.
That's all. Good luck to you, sir.
Thank you.
Michael was given a 90-day sentence, which was eventually discarded, and he was given a clean chit. So what was his punishment? Well, no longer being a police officer. How's that for justice? As if abuse wasn't bad enough, we have yet another killer cop before a judge, and this judge doesn't tread lightly this time.
Defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Former Fort Worth police officer Aaron Dean fatally shot a Tatiana Jefferson through her bedroom window while responding to a call about open doors at her home. He was charged with murder. Here's his sentencing.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in.
Judge, you're one.
The officer stood firm without expressing grief or remorse as the judge proceeded with the sentence.
Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. Hand it please to Deputy Nicholson. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict. Juror number one, is this your verdict?
Yes, Your Honor.
Juror number three, is this your verdict?
Yes, Your Honor.
Juror number four, is this your verdict?
Yes, Your Honor.
Juror number six, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict?
Yes, Your Honor.
Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict?
Yes, Your Honor.
Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law.
The jury ultimately convicted him of manslaughter rather than murder, which saw him sentenced to 11 years in prison.
You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on this case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution?
There is.
You may be seated. Thank you very much.
Tatiana Jefferson was a black American. Her killing drew nationwide protests, claiming that Officer Dean racially profiled her. Do you think the sentence was enough, or was the officer let go easily? As many claim, the sentence does not fully address the gravity of the crime, a theme unfortunately far too common in today's justice system. If you enjoyed this video, I'd like to kindly ask you to subscribe to our channel. It helps us out a lot. And if you haven't already, check out our other series in other countries on this exact same topic. We'll also be returning with more videos on Kiwi policing soon, so stay tuned for that.